Okay, we're good to go. Welcome, everybody, everybody in the room, and also everyone at home who's dialing in to watch us this morning. You're all very welcome to Myerson's and our spring employment law update, and it's great to see so many people here today. And I think we've got about 150 people watching at home as well. So clearly high levels of interest, and not a surprise because there's an awful lot going on in the employment law world right now. And so we will be cantering through quite a lot of content today. But it's very good to see you all here today. My name's Jo Evans. I'm head of the employment team here at Myerson. We're a team of 12 in the employment team, and we're delighted we've just this week been shortlisted for Best Northwest Employment Team by the Manchester Legal Awards. So we're very proud of that. And as well as me speaking today, two other lucky individuals from the team are speaking. We've got Jack Latham, who's a senior associate in our team, and Vicky Fagan, who's an associate in our team as well. So we will be talking to you. I'm going to jump straight to the agenda because, as I say, we have a lot to cover today. Seems to be particularly peaking in terms of employment law changes right at the moment. We stuck with our usual top 10 format so that we can get through as much as possible to keep you all up to date. And the way we're going to run the agenda today, Vicky's going to speak to you first about the first three items, new family-friendly rights, particularly 4 new sets of rights that have come into force this April, menopause guidance and parental leave case. Then Jack's going to talk to us about the next 3 sections, holiday pay changes, culture wars scenario around some case law, and the usual April rates and limits changes as well. And then I'll be returning to do the final 4 sections, all of which are upcoming changes. So I will run us through those. Our plan is to speak for an hour. And then because we have got quite a lot to get through, if we can leave questions to the end, we'll make sure we leave plenty of time to deal with questions from those in the room. For those watching online, if you've got any questions, please do put them in the chat function and we'll come back to you and respond to all of those after the seminar. So I think that's all the introductions that are needed for now. So I will let Vicky kick off and start on family-friendly rights.
Good morning, everyone. Thank you for coming and joining us today. As Jo said, my name is Vicky Fagan. I'm one of the associates in the employment team here at Myerson, and I specialise in pregnancy and maternity discrimination matters, as well as family-friendly rights and responsibilities. So, as Jo mentioned, the first topic that I'm going to talk you through this morning are the 4 new family-friendly rights that came into force on the 6th of April. It's quite a detailed topic, so I've been some quite big changes. Bear with me, I'll try and rattle through these as quickly as I can. So the first set of regulations that I'm going to speak about ultimately extend the right to be offered an alternative role in a redundancy situation. So a little bit of background, the previous law confirmed that those who were identified and confirmed as being made redundant during a period of statutory leave, so that's maternity, shared parental leave, adoption leave, had the priority right to be offered any vacancy over and above anyone else that would be made redundant. And that was long acknowledged that that right and protection only applied to those identified and confirmed as redundant during the period of statutory leave. So if an employee was made redundant after they had returned from leave, then they didn't have this right. The Protection from Redundancy, Pregnancy and Family Leave Act, which was made law in July 2023. And this provided for regulations to be made to extend that right to be offered a suitable alternative vacancy in a redundancy situation. As I mentioned, the regulations came into force on the 6th of April this year, and they confirm a new additional protected period, which starts on the day that the employee announces that they are pregnant to their employer and ends 18 months after the child's birth or placement. therefore extending the protection to those who are pregnant and those who have returned from their leave. The second lot of regulations relate to the rights associated with making a flexible working request. These also came into effect on the 6th of April 2024. Under the new regulations, they remove the need to have qualifying service to make a flexible working request, making it a day one right. So previously you had to have 26 weeks service to be able to make a flexible working application. That's no longer the case. For an employee to make a request, they only need to put it in writing, date it, say that it's a request under the statutory regime, specify the change sought and when they would like that change to take effect, and state that whether they've made a previous application. The new regulations no longer require the employee to explain how they think that change will affect the employer and how that can be managed. The new regulations allow an employee to make 2 applications in any 12-month period, rather than 1, as was previously the case. And it reduces the period of time in which an employer must make a decision and notify that decision to the employee from 3 months to 2 months, although that can be extended with agreement. The new regulations, and sort of the major part of the change, is that there is a requirement now for the employer to consult specifically with the employee if it's not going to simply agree to the change in full. That being said, the new law makes no change to the grounds on which an employer can reasonably refuse a flexible working request. And I've detailed the 8 business reasons on the slide here for you. So all to do with the burden on the business. There is also no change to the level of compensation that can be awarded if the employer unreasonably deals with a request. And that is limited to 8 weeks' pay, which is subject to the statutory cap on a week's pay, which Jack will speak about a little bit later. That is caveated to unless, of course, it is associated with an unfair dismissal or a discrimination claim, in which case the compensation can significantly increase. As a result of the new law, the ACAS Code of Practice has been updated, and I've popped the link on the slide here for you. I would advocate having a look at that. It does contain some helpful and practical considerations for dealing with a request. The third regulations that have come into force on the 6th of April provide a new right to take carers leave. Now, before I go into the detail of the new right, I just wanted to draw your attention to some statistics that I've popped on the slide here for you. 2 million employees, based on the 2021 census, are carers, with the majority of carers being aged 35 to 49 or 50 to 64, and predominantly affects women more than it does affect men. I think those statistics just really put into context how prevalent unpaid carers are in the workplace. Turning to the new right then, any employee who has a dependent with a long-term care need can take 1 week's unpaid leave to provide or arrange care in any 12-month rolling period. I popped on the slide here the definitions of dependent and those with a long-term care need. So a dependent is a spouse, civil partner, child or parent of the employee, but also anyone else who reasonably relies upon them for care. A long-term care need is anyone with an illness or injury or a disability or for anything connected to their old age. So you can see here that the definitions are really quite wide. The leave itself can be taken in either individual days or half days, up to a block of 1 week. And the required notice period is twice as many days as the period of leave required, or 3 days. So it's whichever is greater. The notice doesn't necessarily need to be in writing, although as an employer, you may advocate for that in a policy. But an employer cannot require evidence in relation to the leave request before granting the leave. An employer similarly can't decline a request altogether, It might, however, postpone the leave for operational business reasons if they considered that business would be unduly disrupted if the leave was allowed to be taken at the particular time. If a company is seeking to postpone the leave, then they must allow the employee to take the leave within 1 month of the period initially requested. As with all other family-friendly rights, the employee is entitled to benefit from their terms and conditions, apart from obviously remuneration during that period. And they will be protected from detriment or dismissal because of the fact that they took or sought to take the leave. Now, as I've said, the right is only to take 1 week unpaid leave. And with unpaid leave, the uptake does tend to be relatively low. But when this was originally proposed, 37% of working carers said that they needed carers leave. And as many as 1 in 7 said that they would have to reduce their working hours or stop work altogether if they weren't allowed to take time off. Other surveys also indicate that carers don't tend to talk to people at work about their caring responsibilities, and they often report low mental well-being. So hopefully the right will allow an employee to speak to their employer, create an open culture to mean that they are able to talk about matters and feel a little bit more supported in their working environment. The fourth and final new piece of law that's come into effect on the 6th of April creates a little bit more flexibility in terms of paternity leave. The new regulations mean that paternity leave can now be taken together or split into 2 blocks of 1 week. Previously, you could only take it consecutively. It can also either be taken within 52 weeks, a year of the baby being born, or the due date if the baby is early. Previously, that had to be taken within 8 weeks of the birth. Under the amended regulations, the notice period required for each period of leave has been shortened to 28 days, instead of the 15 weeks before the expected week of childbirth, as was previously the case. Although the employee does still need to give evidence of their entitlement to take the leave 15 weeks before the expected week of childbirth, or as soon as is reasonably practicable. We've got through the first topic. That was a little bit of a chunky one. The second topic that I'm going to touch upon today is the new guidance for employers that has been brought in by the Equality and Human Rights Commission. On the link, I've popped the link to the guidance for you, but just initially wanted to touch upon why the guidance is important. In a survey undertaken by CIPD in October 2023, they found that 67% of those who experienced menopause symptoms said that they had mostly negative impact on them at work. 46% felt less physically able to carry out work tasks. Further research by the Fawcett Society found that 1 in 10 surveyed who were employed during the menopause left work because of menopausal symptoms. Now, we've spoken at previous seminars about cases that have been heard in the Employment Tribunal where menopause symptoms meet the legal definition of disability, or where workers have been discriminated against on the basis of their age or their sex linked to the menopause. And the aim of the new guidance is to explain the legal obligations to employers to effectively avoid such employment tribunal claims, and also provide some top tips for supporting workers experiencing the menopause. So turning to the guidance then, in particular, the guidance suggests that employers should consider undertaking risk assessments, perhaps consider how the working environment, such as room temperature or ventilation, might affect employees experiencing menopausal symptoms. It also suggests offering restrooms or quiet spaces and fans where possible. The guidance suggests that employers could relax uniform policies if applicable and allow employees to wear cooler clothing. Offering flexible working, such as perhaps working from home or making changes to working hours, that might also be helpful as we get into, hopefully, the summer months, and particularly where an employee is struggling to sleep. The guidance also suggests that employers should record menopausal absences separately from other types of absences, so similar in the case that you would with a maternity-related absence. Creating a culture of awareness around the menopause with all members of staff and promoting open conversations to allow those suffering with the symptoms to feel confident in raising issues and seeking adjustments. And linked to that, the guidance suggests that you provide training. Now, that doesn't need to be manager training. That could be a company-wide lunch and learn, for example. It could allow employees sessions to come together and speak about their own experiences. There might also be some more informal routes whereby you have guidance as to the external support available to your employees. And finally, some employers, not all, choose to have a specific menopause policy. If you do have such a policy, make sure that it's reviewed, make sure that it's alive, make sure that your employees and their managers know that it's there and make any changes that's relevant. The last topic that I'm going to cover today is a case update that relates to parental leave. Before I go into the case, I just wanted to remind everyone what parental leave actually is. So you can see on the slide here that it's the legal right for eligible employees to take unpaid time off to look after a child's welfare. The right is to take 18 weeks, although that's usually limited to 4 weeks per year, per child up to the child's 18th birthday. As with all other family-friendly rights, all employment terms are protected during the period of leave, and it's unlawful to put the employee to a detriment or dismiss the employee because they have taken or sought to take parental leave. And that's precisely what this case relates to. So the case is Hilton Food Solutions Limited and Wright. And just to give you a little bit of background, Mr. Wright has an autistic son. He began working for Hilton Food Solutions in March 2019. In late 2019 and early 2020, Mr. Wright had informal discussions with Hilton Foods regarding unpaid parental leave. On the 7th of February 2020, a HR representative of the company emailed Mr. Wright detailing the process to apply for unpaid parental leave. And that specifically said that there needed to be a written request to his manager with at least 21 days notice. On the 14th of February 2020, Mr. Wright mentioned his intention to seek parental leave at a meeting with his MD, which he said was met with an extremely negative response. He subsequently met with a further HR representative to discuss parental leave further. And on the 13th of March, just a month later, Mr. Wright was dismissed by reason of redundancy. Mr. Wright said that the real reason for his dismissal was due to his attempt to take parental leave, and he subsequently brought a claim for automatic unfair dismissal. Now, the law says that, that an employee will be unfairly dismissed if the reason, or the principal reason, if there's more than one, for the dismissal is connected with the fact that they had taken or sought to take parental leave. The company argued that Mr. Wright had not sought to take the leave as he'd not given the specific notification requirements as provided for by their policy and also by Schedule 2 of the maternity and parental leave regulations. This went to the tribunal, and the employment tribunal concluded that it was arguable that Mr. Wright had sought to take parental leave due to the fact that he had made informal inquiries about this and he had stated his intention to take the leave. Hilton Food Solutions appealed, and this went to the Employment Appeals Tribunal. The Employment Appeals Tribunal confirmed that a purposive approach should be taken in considering whether we've got to a stage that could be said the employee had sought to take the leave. It concluded that giving specific notice as required by law will, save in exceptional circumstances, be demonstrating that the employee has sought to take parental leave. However, the giving of such notice is not an absolute requirement, and it's not the only way that the fact an employee has sought to take parental leave could be evidenced. Now, this isn't a groundbreaking case, but I think it's also a helpful reminder for all of us, because even if an employee's gone down an informal route or hasn't gone down the formal route of giving notice, that doesn't mean that they won't be found to have sought to take the leave. And remember, when someone seeks to take the leave or has taken the leave, they are protected from a detriment or a dismissal. I think it's therefore really important for companies to understand what parental leave is, understand the language that might be used by employees in discussing the type of leave, and recognise that managers and/or HR professionals can leave companies in hot water if they're quick to disregard a request or be quite flippant about it just because they consider it to be made on an informal basis. That's everything from me this morning. So thank you very much for your time. I'll hand over to Jack, who will be picking up the next 3 topics.
Thanks, Vicky. So as Joe said earlier, I'll be taking you through 3 topics today. The bulk of my time will be spent talking about the new holiday pay regulations. I'll go through a couple of interesting employment tribunal judgments relating to discrimination. And finally, I'll be going through the changes to the rates and limits, as is traditional in our April seminar. So let's talk about holiday pay. This is Article 7 of the Working Time Directive. It set out that every worker has a right to 4 weeks of paid annual leave per year. Quite straightforward, you would think, but that section, the highlighted section in particular, has caused extensive litigation on what is the definition of paid annual leave. The bad news is that holiday pay is an extremely complicated subject, and I've got about 7 minutes to talk to you about it. The good news is that the new regulations I'm about to go through are not seismic and generally reflect what most employers should be doing. So, turning to UK law, all workers are entitled to 5.6 weeks of paid annual leave per year. That is a maximum of 28 days statutory holiday, which can be prorated for part-time employees. And of course, you could have further contractual rights on the statutory rights, but I'm just talking about statutory leave at the moment. So if the Working Time Directive requires 4 weeks of paid leave, why do we get 5.6? Well, simply put, the other 1.6 weeks is dealt with as UK bank holidays. Because there's this 4 weeks of Working Time Directive leave and 1.6 weeks of what's called Regulation 13A leave or additional leave, different rules apply for those different types of leave. Also, different rules apply for how holiday is calculated for employees with normal working hours. So your standard Monday to Friday 9 till 5 workers, compared to those with variable shifts, such as your night workers or part-year workers, and I'll come on to them later on. So, normal working hours under the Employment Rights Act, holiday pay was defined as basic salary only, disregarding overtime hours. The definition then changed based on a series of EU case law, because if you are only getting paid your basic salary whilst you're on holiday, but usually you'd get things like shift allowances, commission, overtime, you'd actually be getting paid less than your normal wage whilst you're on holiday. And it was seen that that was contrary to the Working Time Directive's purpose and discouraged workers from taking leave. So all these cases came in and they said that for workers with normal hours, holiday pay had to include commission payments, overtime pay, shift allowances, etc. Now, remember, this only applies to Working Time Directive leave, so only for 4 weeks of the year. So for 4 weeks of the year, you have to pay employees all of those extra bits and pieces. This is what the new regulations, the Employment Rights Amendment, Revocation and Transitional Provision regulations, look to do. So it's not a seismic change, as I said, it's just codifying what all this EU case law did over the years. So now holiday pay must include payments that are linked to the performance of the contract. so things like bonuses, length of service payments or qualification payments, as well as overtime payments, which have been regularly paid to the worker in the 52 weeks before the holiday. Now, you'd think that'd be the end of the litigation, but this italics of what's been regularly paid, we envisage will result in a lot more case law to determine what is regular overtime for the purposes of holiday pay. As I said, these new rules only apply to working time directive leave. So what happens to your additional 1.6 weeks leave, your bank holidays? Well, there are three choices for employers. You could either pay all holiday at the enhanced rate. That's what most employers would do, mainly because it's probably the most simple calculation. You could pay perhaps the first 4 weeks at the enhanced rate and the remaining 1.6 at the basic rate, or you could pay bank holidays just at the basic rate and the rest of the holiday at enhanced rates, or you could prorata all of the payments so that that enhancement is spread over all 5.6 weeks of holiday. For employees with no normal hours, so your variable shift workers or part-year workers, so your seasonal workers or term time workers perhaps, there are different pay rules. Devotees of the Myerson seminars will remember me talking about the case of Harper Trust v. Brazel last year. That basically said that if you were a part-year worker, you were still entitled to 5.6 weeks of leave, even if you didn't work the whole of the year, which caused perceived unfairness because these workers were therefore getting a higher amount of holiday proportionate to the hours worked. So almost immediately, the government launched a consultation on the matter, which has led to these new regulations. So these regulations now say that holiday will accrue at a rate of 12.07% of actual hours worked in the previous pay period, which the Supreme Court in Harper said was incorrect, but that's where we're at now. A week's pay is the average of all pay in the previous 52 weeks. And just like the Employment Rights Act said way back when, that includes commission, bonuses, overtime, etc. Always has done. Most importantly, there is no distinction between working time directive leave and additional leave for workers with no normal hours or who work part of the year. So there should be an average of all pay that they've ever received. Finally, on this section, the regulations also deal with rolled up holiday pay. Now, in 2006, rolled up holiday pay was deemed unlawful, again, because it was seen as a deterrent from workers taking holiday. So what rolled up holiday pay is, simply put, is an allowance added to pay to make up for the fact that holiday use later on might be unpaid, effectively. So it's all rolled up into the pay slip. What was found in case law was that if everyone was getting their pay up front, they probably just wouldn't take any holiday because that would then be unpaid. However, these new regulations now permit it again, mainly because a lot of companies were still doing rolled up holiday pay. So rolled up holiday pay is calculated at the same 12.07% of the worker's pay during the pay period. Importantly, from a payroll point of view, is that any holiday pay that is rolled up needs to be clearly stated on the pay slip. And if you have a policy of rolled up holiday pay, this should be clear and transparent. It's worth noting that there's a lot more to these regulations than I've been through today, which I've just not had time to get to. So if you do want to come and talk to me about any more holiday pay issues, please do. My next section is on two cases earlier this year dealing with protected beliefs. So these cases, in one of them, the tribunal found in favour of the claimant, and in the other, they found in favour of the respondent. And it's probably worth going through why that was. But what these cases demonstrate, and you'll see, is that there's a balance to be struck between that not discriminating against people who hold certain protected beliefs, whilst also protecting those employees who might be affected by said beliefs. Before I get into the cases, I just want to go through the background. So under the Equality Act, a religion or a belief is a protected characteristic. I've set out what's called the Granger v. Nicholson test, which shows what a belief needs to do to be protected. I won't go through each of them, but basically it's not a particularly high bar for a belief to be protected. Looking at the first case of Miller versus the University of Bristol. In this case, Dr. Miller was a professor of political sociology at the University of Bristol. He was well known to hold anti-Zionist beliefs. He had described the formation of the country of Israel as a racist endeavor, and he stated that Israel was a major cause of Islamophobia in the UK. Obviously, this raised a lot of complaints, particularly from the Jewish Student Society at the university. And after an internal investigation, it was found that he had breached the university's code of conduct and acceptable behaviour at work policy. He was dismissed because of this. He appealed internally and his appeal was unsuccessful. What happened next was that Dr. Miller raised claims in the Employment Tribunal for unfair dismissal, wrongful dismissal, harassment, direct and indirect discrimination. Unsurprisingly, as I said, it's a low bar. The Employment Tribunal found that Dr. Miller's beliefs did meet the threshold to be protected, as they played a significant role in his life and his academia. It was found that he'd been unfairly dismissed because of something related to the manifestation of his beliefs, and the tribunal found that a less severe punishment could have met the university's objectives. Because of his unfair dismissal, because his dismissal was tarnished by discrimination, it was also found that he had been discriminated against as well as unfairly dismissed. So, second case, the comparison case, is Amuba versus Global Artists and Leicester Theatre. So in this case, Miss Amuba was an actress who applied for a role of a lesbian character in the play The Colour Purple. Following her announcement, an old Facebook post was circulated where she had expressed that homosexuality was a sin and added some religious scripture. Her agency and the theatre then terminated her contracts. She brought a claim for religion and belief discrimination, harassment, and breach of contract. So far, so much like Dr. Miller. However, in this case, her claims were dismissed. So in this case, first of all, she admitted that she hadn't read the script for the play, but if she had done so, she would have resigned, and therefore the tribunal found that there were no prospects of success in the case. It also made a costs order against her, which is pretty rare in the Employment Tribunal against a claimant. She then appealed to the Employment Appeals Tribunal, and in contrast to Dr. Miller's case, they found that she wasn't dismissed because of her beliefs or a manifestation of her beliefs, but because of the adverse effect that that Facebook post had on the play's publicity, the cast, the audience reception, and the reputation of the producers, as well as the commercial success of the production. What's the difference in the cases? Well, the tribunal in Miller found that he was dismissed because of something related to his beliefs, whereas in Amuba, it was because of the commercial context rather than the beliefs themselves. In Miller, it was also noted that as an academic, free speech and debating ideas were a priority, and the tribunal said that it could have a chilling effect on all of academia if he could not profess his beliefs, and this would be to the detriment of society as a whole. Whereas in Amuba, it was a detriment to just the commercial production. finally, I just want to go through the April update to changes in rates and limits. So the most striking changes are to the national living wage. Previously, the national living wage was payable for people 23 and over. That's dropped to people 21 and over. So there's been an increase for 23 and over from £10.42 to £11.44, but a more dramatic increase for those 21 and over from £10.18 per hour to £11.44. I've also put some percentage increases there on the sides of the various rates. And I think it's just worth going through these because I know that I've had calls from clients stating that 10 to 15% raises in national minimum wage and national living wage are basically crippling to some businesses. And I think this will see an increase in redundancies, particularly for lower paid staff. It could see a higher use of 0 hours contracts. And one of my clients actually said that they're not going to pay staff bonuses this year in order to pay for the increase in the national minimum wage rises. Vicky went through a number of family-related changes, and as usual, these rates have risen as well in terms of statutory maternity, paternity, adoption, and shared parental pay. Just worth noting that the changes came in on the 7th of April, and if you do have an employee who is on mat leave at the moment, from the 7th of April, their statutory maternity pay would increase. Finally, in terms of dismissal and discrimination, as Vicky went through earlier, a week's pay has increased from £643 per week to £700 per week. That affects things like redundancy payments and an unfair dismissal basic award, but it also affects the things like flexible working request awards, which have now seen a raise to a maximum of 8 weeks, which is now £5,600. That's all from me. Just a reminder, all of these rates are in your packs, and I will hand you over to Jo.
The final stint, as I said at the outset, I'm going to talk about quite a few changes that are in the pipeline and coming up that now's the time to start preparing for. The first one is the new duty to prevent sexual harassment of employees. We've talked about this on a number of occasions at previous seminars. It's long been trailed, but it is finally coming into force this year. So the journey to get to where we are now, and a bit of background, we obviously have the Equality Act of 2010, which specifically prohibits sexual harassment in the workplace and makes employers liable for their employees' actions. That's not changing. That will continue as it is now. However, skip forward to 2017, and we had a series of Hollywood scandals, which really gave global prominence to the Me Too movement and real pressure to make changes to protect women and girls from sexual harassment and sexual violence. So politically, governments needed to be seen to be doing something about this issue. In the UK, there was a survey in 2020 by the Government Equalities Office, and that survey results were that 29% of employees experience sexual harassment at work, and of those, only 15% reported it. So there was a real need to do something more than the legislation that is in place already. And so that has resulted to the process of creating legislation, debating legislation, and that finally became the Worker Protection Act 2023, and that will come into force in October this year. That puts a new duty on all employers to take reasonable steps to prevent sexual harassment of employees in their employment. And there are two consequences of not doing so. Firstly, any compensation that an employee wins in a tribunal claim for sexual harassment is increased by up to 25% if this new duty is breached. Secondly, the Equalities and Human Rights Commission can carry out a formal investigation of your organisation. Those are the legal levers to make employers take action and take this new duty seriously. Of course, as good employers, there's an opportunity here to be ahead of the curve and to demonstrate to employees that this is something that you do take very seriously, and you are putting all proper steps in place if you haven't already. So the duty is to take reasonable steps. What are those reasonable steps? None are prescribed at all, but the areas to consider are firstly, making sure you've got a robust anti-harassment policy and reporting procedure. And that involves looking at your organisation as a whole and all operations within it, and thinking about where are the risk factors, where does protection need to be put in place. Might that be social events, for example, where there needs to be some careful guidance, thinking about the whole organisation and having an appropriate process, a policy in place. Clear communication of that policy to your employees, confirm to your employees you take this seriously, and that there is a process and there are sanctions for those who do carry out sexual harassment. Make sure you appropriately train staff, think about what training do you need in your organisation. And of course, investigate any complaints if they do arise and take action if there is found to be wrongdoing. So the EHRC is updating its technical guidance and its code of practice on sexual harassment at work to take into account this new duty. It's not out yet, so watch out for that, and that will no doubt have lots of further useful guidance to lean on. It's worth also noting that the future direction of travel, I think, is that this is probably the start. And at the moment, this new duty applies only in relation to employees committing sexual harassment in relation to their colleagues. I think it's really likely that that will be expanded and covered third parties as well. So visitors or any other individuals who your employees come into contact, the duty will extend, I think, in due course to make sure you're taking reasonable steps to prevent sexual harassment in relation to those third parties as well. Change of topic, fire and rehire. Again, something we've talked about a lot in previous seminars. Employers who need to make a change to contractual terms, that might be for cost reasons, it might be for strategic reasons, organizational, operational reasons. It does crop up a lot. And to make a change to contractual terms, you have to get an employee's consent. You can't unilaterally impose contractual changes. If you can't get consent of your employees, then the last resort has always been getting to the point of dismissing and offering re-engagement on the new terms. And that's the way you get round the need for consent to alter terms. And that's been frequently used for many, many years to change terms and conditions by many, many employers. The practice, however, came under spotlight in 2022 when P&O Ferries dismissed 800 employees overnight and replaced them with cheaper agency staff. We'll all remember the story. It was headline news for a long while. Ironically, that wasn't a fire and rehire situation at all. It was a fire and replace situation. So, but nevertheless, it had huge profile and huge political pressure to deal with the concept of fire and rehire. So the government produced draft code and had a consultation process in 2023. That consultation is concluded and a new updated statutory code was published in February. And I've put on the slide the quote, which is the sort of the feeling behind the purpose of the new statutory code: to ensure employers take all reasonable steps to explore alternatives to dismissal and re-engagement and engage in meaningful consultation with a view to reaching an agreed outcome in good faith and with an open mind. That's what you're now being asked to do. So it's not saying you can't fire and rehire, but it does need a much more careful approach than that's been used to date. So the statutory code comes into force in July. And interestingly, we had a client this week, we think, involved in a situation where 3 months notice was served, we think tactically to make sure they got in before the July changes. So yes, there is an opportunity, a very small window, if you were minded to take that kind of an action. In summary, what are the new obligations? Not raising the prospect of fire and rehire too early, not using it as a threat, and instead concentrating on trying to reach agreement. So having a focus of, we need to try and reach agreement. Provide detailed information about the changes to employees or their reps, and there's a prescribed list, very long list of information that needs to be provided. If you have a recognised trade union in your organisation, then that union must be involved in consultation, even if you're only proposing changes in relation to one employee. You then need to consult meaningfully and for as long as possible. So this isn't a tick box exercise. And at the end of that process, you have a duty to sit down and think about your plans again. Is the change still needed? Are there alternatives? Have you thought through all the negative consequences of forcing through a change? And all that obviously would need to be documented very carefully to demonstrate that you've complied with the code. There's also an obligation to involve ACAS and seek their advice before raising the prospect of fire and rehire. And only then is the point at which it's permitted to raise the prospect if you still believe it's necessary, and it's a last resort. At that point, you still then need to follow all the usual fair rules that we would currently advise you to follow anyway to avoid unfair dismissal claims and failure to consult claims. But that's the additional set of steps that will be expected going forward. These apply regardless of the number of employees affected, on top of existing fairness and collective consultation obligations. And if you do fail to comply, there is no freestanding claim, but compensation in associated claims, for example, unfair dismissal claims, can be increased by up to 25%. And that, if you're dealing with a large number of individuals, can be a very significant financial burden. So that's going to be the new rules, as I say, from July. The note there is that if we have a Labour government, their current proposal is to ban fire and rehire completely, which will create an interesting situation, but that's their stated aim at the moment. Some other changes, because there's lots. A right to request a predictable work pattern. This stems back to the Taylor review of years and years ago, where it was recognised that one-sided flexibility in an employment relationship needs addressing. And the result finally now is the Workers' Predictable Terms and Conditions Act, which comes into force in September. So any worker who has unpredictable hours or days of work, or even unpredictable length of employment contract, and wants a more predictable work pattern, can now formally request that. So casual workers, annualized hours workers, 0 hours workers, you have to have 26 weeks service. You can make 2 requests every year, and employers have a month to respond, so not long. You're not obliged to agree, but you must show that you've acted reasonably. So again, this isn't a tick box exercise. There are a list of grounds for refusal. They're very similar to the grounds that you can rely on to refuse a flexible working request that Vicky talked about earlier. But as I say, you need to demonstrate you have properly thought about the reasons if you are going to refuse. The penalty has not yet been specified in the legislation. We're guessing it's going to be 8 weeks pay to match with the flexible working regime. That would seem logical but that's still to be confirmed. And tribunals can force you to reconsider a request as well. So you needn't agree, but I'm sure you can see this could be a significant administrative burden, particularly if you're in a workforce where you've got a number of people who don't have predictable terms. We expect an ACAS code. There is a draft which is being consulted about, so that will give us extra guidance in due course as well. Next one, neonatal care leave and pay. We have a new act covering this, and this is currently suggested that it will come into force April 25. This applies when a baby needs specialist neonatal care after birth. Currently, employees need to use maternity leave, paternity leave, holidays, unpaid leave, or any compassionate leave their employer might give them. And a survey by Bliss has said that 36% of fathers or partners are signed off sick if they face having to deal with a new baby taking neonatal care, and 11% of parents leave their jobs. So this is aimed to try and ease that burden and help individuals in that difficult situation. So neonatal care leave will be a day one right. It applies if a baby receives neonatal care of 7 or more days in the first 28 days after birth. And the right is to take up to 12 weeks leave and to be paid at the statutory maternity pay rate. This is on top of any maternity and paternity leave and pay, and there's the right to return to the same job after taking that leave. So there'll be more detail on this. We're looking at April 25, so not imminently, but it's on its way. It is going to come into place. I thought I'd mention a few others. These are the sorts of things that are out there and people mention and articles are written about them. And I thought I'd just pin down where we're up to on these other family related rights as well. So bereavement leave is a day one right. The plan is to introduce a day one right for a father to take paid leave if the mother dies during a parental leave period. So this is in addition to the current parental bereavement leave that applies if a child dies, which was introduced in 2020. And this is proposed as a new right, and it's currently going through government. It's a private member's bill, as a lot of these new rights are these days, but it does have government support. So we're assuming that that will work its way through the process and become a right, an additional right. Miscarriage leave has been talked about. In Scotland, there is a plan to introduce 3 days of paid leave for public sector workers. There's pressure to extend this across the UK. There are no specific legislative plans yet, but NHS England have said that they're proposing to introduce 10 days of paid leave for mothers and 5 days of paid leave for fathers who experience miscarriage. And large employers now are introducing this. We're seeing articles about organisations like Tesco's, Aldi, John Lewis, Santander have introduced miscarriage leave. So it's something that you might want to put on your list to think about, albeit that there isn't a legislative path at the moment. Fertility treatment leave, again, lots of talk about this. No legal process in train at all, but there are CIPD and Fawcett Society guidance on how best to support your employees going through fertility treatment. And again, I suspect this is something that is going to become more and more of a topic that employees are going to expect their employers to engage with them about. Moving on from the family regime to some other changes, a couple of government-backed changes. Non-compete post-termination restrictions, there's been a lot of discussion about whether they should be banned completely. So those restrictions that say when you leave your job, you cannot go and join a competitor for a fixed period of time, used all the time by employers to protect their businesses when key people leave. The government's position is not to ban them, but to reduce them to 3 months, which is a lot shorter than many current post-termination restrictions in place now. The government produced a paper on this in May last year, which made it seem that this was very imminent and it was likely to be enforced very soon. However, we're now in a when parliamentary time allows scenario, which suggests it's probably not at the top of the agenda and that there are bigger things that the government's looking at the moment. So I think it's still going to appear at some point, despite the fact that obviously there may well be a government change. It's still out there, and internationally there is a trend towards limiting non-competes. So it's really important when you're employing key people to make sure you've got good notice periods, good garden leave provisions, because those are your best protections in relation to competition anyway, and that hopefully future proofs if there are changes to restricted covenants. Mention in passing TUPE consultation requirements where less than 50 employees are involved in a business or less than 10 are transferring. The need to elect representatives is going to be removed. And a reintroduction of employment tribunal fees has been put on the table. The idea is a £55 fee to issue a claim. For those that remember the heady 2013 to 2017 days of tribunal fees, these are at much lower levels than the £1,200 that needed to be paid to bring a tribunal claim back then. So maybe an impact to nuisance value claims, perhaps, but we'll see. And finally, last one to mention to you, we're nearly there, hang on in there. I wanted to talk about the proposals by the Labour Party. Obviously, we're very likely to get a general election this year, if not early in the new year. And polls suggest that the government will be changing at that point as it stands right now. And the Labour Party are promising fundamental change to employment rights. So this is something that we all need to be thinking about quite carefully. Rattling through the main ones, in the green paper that they've produced called A New Deal for Working People, they are proposing to amalgamate the current employee and worker status that we have into one. So there would just be the genuinely self-employed and workers, and all of those workers would have the full scale of employment rights. So that could massively impact some businesses that have a number of workers as opposed to just employees. Unfair dismissal rights from day one, as opposed to the current 2 years. Again, something employers are very concerned about. No cap on unfair dismissal compensation, as compared to the 1 year cap, 115 grand cap that we currently have. Extending time limits for tribunal claims. Currently, most tribunal claims have to be brought within 3 months, which is a short period. And the proposal is to extend that to 6 months, which is less controversial than some of the other suggestions. And no waiting days for SSP, that will kick in on day one. Final couple of points from the Labour Party. Limit 0 hours contracts. They're not planning to ban them, but limit them and to deal with unpredictable contracts. They are planning to ban fire and rehire practices, as I mentioned before. Wholesale reform to union and industrial relations and industrial action laws, unpicking a lot of the changes that have been made by the current government. And a new right to switch off, where employers aren't to contact their employees outside working hours. Although the latest I've read on that is that that's being watered down and will be not so much a legal obligation, but a charter of good conduct, I think is the current plan. And I think there's clearly going to be a level of consultation and debate about all of these provisions. And there is a recognition by the Labour Party that there needs to be an engagement with the business community about the impact of some of these in particular. Having said that, they have pledged to introduce an employment bill within the first 100 days of entering office. So we do need to be ready and expect the change. That takes us to the end of what we wanted to talk about today. Hopefully you found that helpful. And an opportunity, if anyone's got any questions that they want to raise, either now or we can stop and have coffee and pastries. Apologies to those joining us online, but and can chat over those. Does anyone want to raise any questions? Yeah, of course.
So, with the flexible working, because that's changing the whole dimension. Now, 5 days. With that, it comes with a reasonable adjustment to be made either at home or in the work. What is your take from the perspective of businesses not making the reasonable adjustment? If, let's say, employee allowed now to work from the employment.
Sure. Sure. So the question is just so for those that couldn't hear it, is how, I think, summarising, how seriously do you need to take flexible working requests? And I think the answer to that is you do need to take them seriously. You are expected to look at them seriously and be prepared to go through the reasons why a flexible working request may or may not be able to work. And the risk is if you don't, obviously there's a financial penalty under the regulations, but also you've got a dissatisfied employee and you've got potential discrimination claims with uncapped compensation. So of course there's a balance and you can't be expected to put in place any flexibility if it's not going to work, but you are expected to take that quite seriously. It's a difficult one to give a more specific answer because every single case is on its own facts. It will depend on the role that's carried out by the individual, the business that they work in. But I think the way I would approach it is have a starting point of what can we make work here, rather than we're just going to find a way to say no. Because I think employees, the labour market's quite difficult in some sectors, and employees do have that expectation of being able to talk to you about flexibility. Does that help? Right. Anyone else? Hi. Vicky, do you want to?
I don't think there has been any initial consideration or clarification on that, but I think practically the law is already in effect. So you had the knowledge prior to the law coming into effect. You're going to have the knowledge after the law's come into effect. I don't think there's a way to get around just because someone notified you before the 6th of April that they no longer have this protection. No, I don't think there's a way to get around that.
Notify again.
I'll take that again. So sorry, yes, was if someone had come for an interview where it's a 9-to-5 job, and then the first day that they start employment, they turn around and say, actually, I only want to work 3 days. Could they? The short answer is yes, they could. But remember, this is only a right to request. It's not a right to have that request met. Now, as Jay mentioned, you've got the obligation to consider it properly. And if you're not going to agree to it in full, you've got to specifically consult. So that's the inform the employee, to work with the employee to find a working situation. Because ultimately, if you've got someone that you liked at interview stage and you thought was a great fit for your business, is it worth trying to work with them moving forwards than trying to start the whole recruitment process again? It might well be, or it might well be not, Exactly. And remember, one of the 8 business reasons that you can refuse a flexible working request is the impact that has on other employees, the impact that it has on the work. So the short answer is yes, but there is those obviously 8 reasons to refuse it.
I've literally had the interview and been offered and accepted the job based on the terms and the structure that you'd set out. It's in a way easier to reject a request immediately, isn't it, than someone who a year in, 2 years in, 3 years in says, I need a change because of whatever's going on at home, or I'd like to ask for a change. It feels instinctively that being able to reasonably refuse that kind of request right at the start of the employment would probably be easier, but the right is there, and you would still need to take that seriously.
Advertised role that's 9 to 5, Monday to Friday, for example, you've already gone through that thought process as to why that's necessary. Obviously, you know, in this day and age, sometimes it isn't always necessary, sometimes it is. So the fact that you've already gone through that thought process makes it easier then to rely that thought process into one of those 8 business reasons that effectively you're going to use.
Anything else? We'll go and grab some coffee. Just remains to say thank you for coming along. Thank you to all those who've joined us remotely as well. We have videoed the session today, and we'll send you all a copy of that so that you can watch it again whenever you want to. And Cam does an amazing job of splitting it all up. So if you needed to go back to just the flexible working section, you can easily go back to that section. But we will send that round and you can share that with colleagues in the office as well. There are feedback forms in your packs. We find it really, really helpful to get any feedback from you. So if you wouldn't mind filling those out. Likewise, those are watching remotely, if you have got any feedback or if you've got any topics you'd like us to cover in the future, again, we find that really helpful. So please do let us know, drop us a note, and we'll follow up with you on that. One final thing, I just want to mention Myerson HR to you, which is something for you to have to think about. This is our fixed fee retainer service where we provide our service for a fixed cost, which for a lot of employers, particularly in these difficult times, is an attractive way to engage with your lawyers. So if you wanted to talk to any of us about Myerson HR, obviously please do speak to us at any point. That's great. But thank you very much for coming. It's been lovely to see you all, and all have a good day. Thank you.